Your book has now given rise to these series of House Judiciary Committee hearings in the US. If we could talk perhaps about the case that you make, which is very strong, that the lawyers for Dick Cheney and Donald Rumsfeld in the Office of Legal Counsel, and I think by implication, although you don't spell it out, also those politicians, are responsible for war crimes. And you say of the lawyer, you go to talk to a European prosecutor and a European judge at international law, who basically say, I think that those people should be very careful where they go if they travel outside the US. So can you tell us how international law could make those people responsible for the war crime of torture?
Just by way of context, there's no question in my mind, or indeed of the mind of the most senior US military lawyers, since they've testified to that effect before Congress now, that the treatment of Mohammed al-Qahtani was a war crime. He was, well, some would say tortured, others will say abused in a way that constitutes a war crime. And in fact, that has been in effect confirmed by the US Supreme Court. The techniques that I have written about were rescinded in 2003, although not before they had migrated to Guantanamo, and I tell that story also. But a few years later, in June 2006, the Supreme Court of the United States overturned President Bush's decision that the Geneva Conventions did not apply at Guantanamo, which was the basic decision that allowed these techniques to be adopted. In making that judgment, which was by a small majority, 5 votes to 3, one of the judges in the majority, Justice Anthony Kennedy, wrote that he raised the spectre of war crimes. And one of the people that I met with happened to be with Rumsfeld's lawyer on the day that judgment came down, having lunch with him, and described how Jim Haynes turned white as a sheet, recognizing, given his role in the sign-off of these techniques, that he himself was now implicated in war crimes. There are many most senior military lawyers who believe that these people are war criminals. To give you an example, shortly after the book came out in the States, in May, I received, via a close friend, an anonymized email from a serving 4-star Air Force general who simply said, I want to communicate to Mr. Sands that I've spent much of the past 5 years working with these two men, David Addington, who was Dick Cheney's lawyer, and Jim Haynes, who was Rumsfeld's lawyer. I hope they hang together. I mean, the feeling of anger in the US military is extraordinary because their good reputation has been deeply, deeply damaged. So there's no question that war crimes were committed. The issue of responsibility, of course, arises. I've focused on the lawyers. I haven't a particular interest in that because I'm astonished that these lawyers allowed this to happen. But of course, the decision-making goes much higher. The decision-making goes, if you pause for a moment, ask yourself the question, what were Mr. Bush's lawyer, Mr. Cheney's lawyer, and Mr. Rumsfeld's lawyer doing at Guantanamo on the 25th of September 2002? They weren't there on a frolic. They weren't there on some sort of junket down to Guantanamo for the day to have a bit of fun. They were there at the instance of their political masters. This goes straight to the top. It goes all the way up to the President, the Vice President, and the Secretary of Defense. And I'd say also that in Britain, where I know the situation well, and where there has been a big scandal in relation to Britain's involvement in the parallel interrogations under the doctrine of extraordinary rendition, which applies also in relation to Australia and the Habib case and the role of the Howard government and Mr. Ruddock, the former Attorney General, I've got no doubt that the leadership in Britain, probably also in Australia, has a degree of responsibility, either because they knew what was going on or because they willfully turned a blind eye to facts that would indicate that they were complicit in acts of their allies. So this poses a very difficult issue for the next President of the United States. What do you do about the issues of personal responsibility of people at the top of the government? We've had hearings in Congress about it. Many options are now being addressed. The group of 54 congressmen wrote a letter to the present Attorney General asking him to appoint a special prosecutor to investigate war crimes. That's been turned down. Obviously, Mr. Bush's Attorney General isn't about to do that. But the next president will have to look at the issue again. It might be that it's investigations for criminality, it might be that it's truth and reconciliation, it might be a 9/11 style commission of inquiry. But what can't happen is there can't be immunity in the United States, which has been adopted, you'll be interested to know, under the Military Commissions Act, for any person who is involved in this decision-making process. That immunity can't spread outside the United States, and so the possibility of Pinochet-style proceedings is very open and live in relation to all the people in the decision-making process.
That's interesting because we have an example close to home which shows, I guess, the difficulty in a succeeding government of prosecuting the one that went before it. A very good case was made again by Julian Burnside that the Australian government, that John Howard and Philip Ruddock were responsible for war crimes and specifically torture because of the mandatory detention, the mandatory indefinite and extrajudicial detention of innocent people in camps in the Australian suburbs and children. And the international law on that issue isn't even so necessary in this case because the international law has been adopted as part of the Australian Criminal Code in Section 268. So Julian was making the case in 2003 that according to our own domestic law, Howard and Ruddock and then subsequently Vanstone were responsible for this domestic crime that reflected the international law provisions that you talk about in your book. At that time, the Attorney General had a veto effectively over proceedings against himself and the Prime Minister. But we have had a change of government now, and it seems to me that the political likelihood of anything happening there is extremely remote. And I wonder how you assess the political reality of the next, either John McCain with his own experience of torture or Obama government in the States actually doing the things that you say.
I think it's very, very difficult for one country to prosecute its own, and all the more so its own former heads of state or heads of government in relation to war crimes. It doesn't happen. The case that I'm most familiar with is the Pinochet case. That, of course, didn't happen in Chile. It took a Spanish prosecutor, a Swedish prosecutor, a Belgian prosecutor to indict Mr. Pinochet, and when he turned up in London, he was arrested, and that opened the chain of events that allowed some form of justice ultimately to be done. I don't think one Australian government is likely to prosecute individuals at senior levels of government from another predecessor Australian government. And I don't think a United States government is going to be able to do that either. They're going to have to find some other ways to deal with these scenarios and to deal with these situations. But it's a very real issue. We've just had a judgment in the English High Court on Thursday in a case that I'm involved with, which is very parallel to an Australian case concerning Habib. I was amazed. I've been, as I said, on holiday in Australia for the last month, and I was on a beach, I think up in Queensland, in Mission Beach, reading a newspaper and an interview with the former Attorney General Philip Ruddock, in which I was amazed to read. It was a sort of mea culpa, although I think that's a sort of generous way to describe it, of what he had been up to over the past few years. And I'm going to be careful not to weigh into facts of cases that I don't know a great deal about. But I was astonished to read his unwillingness to accept that in circumstances in which an Australian national has been rendered subject to extraordinary rendition to a country which may well be torturing him, it didn't occur to him that actually it would be a useful and appropriate thing to do to inquire with the Americans what was being done to this man. In Britain, the High Court has ruled on Thursday that when the British government, through the Secret Intelligence Service personnel, did that, it was complicit in the torture. And it raised questions of individual criminal responsibility of British nationals, Secret Service people, who were involved in the decision-making process. And I think exactly the same principle arises here, but it is difficult. History shows it is very, very difficult for one country to judge its own, and that's why we've had this move towards international criminal tribunals and Pinochet-style proceedings. But what we do know is that so long as these issues are not cleared up, they fester, they cause bad feelings, they harm relations between communities, and some efforts do need to be made to clear up these issues, or they go on and on and on. And of course, no country knows that better than Britain with its experience of the IRA.
I was interested particularly in your focus on the lawyers, and towards the end of your book you seem to be saying that lawyers owe a duty to the democratic process and to individual rights in a way, not to try and not to advise the politician of ways to get around that. I was briefly quite a bad lawyer, and that doesn't really ring that many bells with me, because I think, tax lawyers are out there busily trying to legally circumvent, what the law is trying to do and so on. I come from a lawyer-hating family, and so I know all the quotes, and, I think Keats said we can class the lawyer in the natural history of monsters, or Shakespeare once saying, first thing we do, let's kill all the lawyers. I think that the reason for that is that autocratic governments, and we're seeing moves towards that in these executive decisions, want the lawyers to do their bidding. A former colleague of mine in the Office of International Law in Australia was asked to justify Australia's involvement in the Iraq War. This is 10 years after I left that job, but your book gave me a kind of frisson of horror that I may have been in the situation of drafting a memo for John Howard. I can't imagine, actually my imagination fails me there, but justifying this, and he's copped a lot of flack for it. I think that it's a lot to expect of a lawyer in their job to refuse that, and yet you do expect it, and we do expect it. So do you think that there's some way of changing that? What would you say?
I work as a barrister.
No offence.
I work for lots of different states, and most of my work is international law. So I work for government. Some of them are dodgy, some of them are fine. And often I and other barristers and lawyers in this country find themselves in situations of wanting to push the line as far as it goes. And I think that's a normal thing to do. But the question is, what do you do when you are asked to cross the line? And I'm very, very clear. You don't cross that line. You have a higher responsibility. In our systems, Western democracies, Britain, Australia, United States, lawyers are guardians of legality. They're guardians of constitutionality. They have a responsibility to keep things within lawful limits, not simply to do what the lawyers want. In Britain, we've been acutely aware of this. We had a situation in Iraq, famously, I've written about it, in which the former Attorney General, Lord Goldsmith, assisted by others, including the former Lord Chancellor, Lord Faulkner, crossed that line. They changed their mind on the legality of the war in Iraq in a 10-day period in circumstances which are frankly very dubious, which have never been explained. That has become, interestingly, a source of popular cultural amusement in Britain. There was a wonderful sketch by a well-known stand-up comedian in Britain. Some of you will know him, Rory Bremner. I was sitting in my office one day at the university and I got a phone call from Rory Bremner saying he was going to do a sketch about the legality of the war in Iraq. Could I help him? He's a famous mimic and impersonator. I first thought it was a friend of mine impersonating Rory Bremner, but it wasn't. It was actually Rory Bremner. And I ended up having 2 half-hour meetings with him. I was very impressed by all the research he did. And a couple of weeks later, there appeared on Channel 4, the Rory Bremner Show, and he started a new series of sketches, the law firm of Faulkner and Goldsmith, the lawyers who give you the advice you want, irrespective of what the law says. And it has become a theme, I think, in Britain, in the United States, in Australia, that a small coterie of lawyers have acted in the service of the executive in circumstances in which we face a very real threat of terror. I don't minimise the challenge our countries face, but in which they should have known better and they should have done better, and they have not. And I think it is right to criticise them for what they have done wrong.
I think we're going to open it up now for questions, if anybody has any.
So if we've got some questions from the audience, either of Philippe and Anna. Philippe has said that because he's a barrister, well, he hasn't actually said because he's a barrister.
You've got to stop taking the piss out of me on this.
Take a couple of questions at a time and then he'll answer them. So if you'd like to put your hand up.
The role of the media. I don't know whether you've addressed it in your book, but there was a deafening silence from much of the media in all this. Would you care to comment?
I'm just interested in the idea of presidential pardons. When Clinton, I think it was his last day in office, he had put forward a lot of presidential pardons. And I'm just wondering what's going to happen on maybe Bush's last day in office. And I know you're referring to people, I suppose, who haven't been charged yet, but what about the ones who might be convicted before he leaves office, whether he might issue some pardons for them?
On the issue of the media, I do touch on the media quite significantly. I mean, that played a role in a number of different ways. Anna and I had been talking beforehand about one of the more astonishing discoveries I came across when interviewing some of these characters. And the book is a sort of trail of weird and wacko characters in the United States who astonishingly agreed to talk to me on the record. One of those people was Diane Beaver, the lawyer down at Guantanamo, and one of the stories she told me was the role that the television program 24 had played in creating a culture in which abuse could happen. And she described to me a television program that I'd actually never heard of when I met her. I'd never watched 24. I've now watched it. The second series was beamed into Guantanamo at the very moment that they were authorizing all these techniques of interrogation. And it sends out a signal that abuse works. It produces meaningful intelligence, meaningful information. That was compounded by the media giving a great deal of attention to a very well-known American law professor, Alan Dershowitz, in precisely those periods, August, September, October 2002, in which he's going around from one television studio to the next, writing one op-ed opinion after the other, saying basically, look, since torture's going to happen anyway, let's institutionalize it. Let's create a system of torture warrants in which judges will sign off with the president's support in particular individual cases. And if you go back and check the media of the United States in the period until CBS's flagship program 60 Minutes broke the story about Abu Ghraib, you will find that they buried their head in the sand about Guantanamo. They buried their head in the sand and did not allow a contrary narrative about abuse and interrogation to be run in the media. So I think the US media in particular bears a singular responsibility, the mainstream media, for allowing a lot of this to happen. The issue of presidential pardons is very much in the news. I mentioned this piece of legislation, the famous Military Commissions Act of 2006, which purports to give an immunity to any person involved in these interrogations that took place between September 2001 and December 2005. Blanket immunity from criminal investigation in the United States. But they are worried in the administration that this purported blanket immunity will not withstand constitutional challenge in the courts. And so what is being suggested, and there's quite a lot of talk about it on the blogs, is that President Bush, as he leaves office, will pardon the most senior of his decision makers, including the lawyers, including Alberto Gonzalez, for their involvement in this whole sorry, sordid, dreadful episode. That pardon will have no more effect than an immunity outside the United States.
I'm not sure that I actually understand what rendition is, but let's assume it's a system whereby you can dump, in quotes, people in your custody, whether it be as unlawful combatants or otherwise, into a country or countries where you willfully, let's say, abandon them, turn the blind eye, not knowing what may happen to them or not inquiring as to what may happen to them in order to get the information you're seeking. Why wouldn't that constitute a war crime? And why wouldn't the administration on that sort of tenuous link or not so tenuous link be culpable in terms of war crimes?
Good. And if we could just pass the mic down to the gentleman third along the front row. Thank you very much.
Thank you. I'd like you to comment on what the future holds in terms of international indictments. And I don't mean specifically by, say, the International Court of The Hague, but by individual governments. So you've referred to General Pinochet. I understand that Henry Kissinger is indicted in Holland. And it seems to me that that might be the way the broader world is able to bring people to justice and to enable a message to go to people that says there will be justice.
On the answer to the first question, the answer is absolutely on the facts you identify that could constitute a war crime. It's complicity or participation in torture or complicity and participation in a violation of Common Article 3 of the Geneva Conventions, which prohibits, very least, outrages against human dignity. But it's not hypothetical. The case in the English High Court that's publicly available, it was reported in yesterday's Age newspaper and in all the other mainstream Australian media, in that case which involved the transportation of a British resident from Pakistan to Morocco, where he alleges he was tortured. The courts invited a member of the British intelligence services to obtain criminal defence counsel and warned him of his right against self-incrimination as the case unfurled. Plainly, the two judges who sat in that case accepted your proposition that if a government knowingly or willfully turns a blind eye to facts in which it is likely or possible that a national or resident of that country is being transported by a third country, the United States, for interrogation in circumstances in which a reasonable person would conclude that person is going to be tortured, that constitutes potentially a crime, which is why I think the issue of responsibility in this country appears to go directly, at the very least, to the Office of Attorney General in relation to the case of Habib on the facts as I know them. Now, that allows me to segue into the gentleman's question at the front. You know, it's clear even within Australia, within Britain, different people, reasonable people, have different views about these things. There's going to be a whole swathe of the community in Australia and in Britain and in the United States who's going to say, we faced a fundamental threat, we faced a fundamental challenge. In those circumstances, it was right for us to take these minimum measures necessary. And that's why I think there is not going to be even a political consensus in our countries to even begin the process of investigating, by reference to the criminal law, facts which arise in circumstances of real difficulty that I'm describing, which is why third countries become important. I devote, right at the end of the book, I thought I needed a sort of reality check. Had I lost the plot? Had I, the US Supreme Court's talking about war crimes, the American media's now talking about war crimes. The facts struck me clearly as crossing a threshold of torture, but had I, I couldn't see the wood from the trees anymore. So what I thought I'd do is identify, and I do it anonymously in the book in terms of the individuals that I speak to, a European judge and a European prosecutor who had been experienced in prosecuting international crimes in the domestic court context. European country, I met with them in a European capital city. I laid out all of the material I'd come across. And I said to them, okay, is this complicity? Is this participation? They went through all of the materials. They were particularly struck by the immunity provision. It's sort of an admission of guilt. You adopt the Military Commissions Act and you basically say, anyone who's been involved in these interrogations in the last 5 years, they cannot be investigated. It's a bloody stupid thing to do, excuse the language. And that's what they said. It's a bloody stupid thing to do. Not least because one of the limits on foreign countries investigating is that there is a rule of complementarity. It's first and foremost for the country in which the act occurred to investigate. And it's only if it doesn't happen, as it didn't happen in Chile, that third countries will look into it. By adopting the Military Commissions Act, they've created the very conditions in which the premise of your question is more likely than not to come to pass. That third country prosecutors will say, this was a war crime, we are going to investigate it, and if this man sets foot in this country, we will arrest him. And I think many of these people that I write about will not set foot outside the United States again.
I just wouldn't mind adding a comment on that to bring it, just to refer to David Hicks. With the immunity provision, it does look very much like an admission of guilt. And the plea bargain, otherwise known as the gag order, on David Hicks, which is an agreement between him, a prisoner, and the US government, has in it that David Hicks has to agree that he has not been illegally treated by any person or persons while in the custody and control of the United States, including during the period after his capture and transfer to US custody in Afghanistan, and through the entire period of his detention at Guantanamo Bay, Cuba. And further, he agrees that his entire period of detention as an unlawful enemy combatant was based upon his capture during armed conflict and was lawful pursuant to the law of armed conflict.
It's just absurd. I mean, it's just not worth the paper that it's printed on. And it's shocking if it turns out the Australian government could in any way support or condone that kind of agreement. If you have committed a war crime, no piece of paper is going to allow you to get off the hook. It's as simple as that.
My understanding is that that piece of paper was drafted with the help of representatives of Australia in the US.
Well, if that is true, it is deeply shocking and shameful.
I've got a question right over on the right there. We could just take that. We may not have time for... Is there another question up there? Right, just one lady here and then one further up, and that's probably it.
Hello, hi. I'm interested in what you said, Philippe, about how, first of all, how you had great admiration for the United States in its role in the role that it played in making international law strong, and your disappointment that they took, that they were so instrumental in breaking its or damaging its strength when they agreed to go to war in Iraq. I'm interested in where your views on the future and where you see strength in international law, given that the US has stepped down.
Thank you, and there's one just up past the steps. Thank you.
You half answered my question before, but when you say that the paper, the gag order isn't worth the paper it's printed on, given that part of the gag was that David Hicks couldn't profit from exposing any of the details or telling his story in any way, do you think if he decided to tell his story or give it to someone to tell, what would be the chances of him being prosecuted? Because I know that's one of the things that worries him. And of course, he should be allowed to profit from it.
Sure. Again, I don't know enough about how Australian decision-making processes work to know how the prosecuting authorities in Australia would decide to act in the event that he spoke publicly about the circumstances.
Sorry, madam, we can't actually hear you down here, so we might just need to have Philippe...
Just one little thing. Wasn't it his deal with the US, not with the Australian government, with the US government?
But presumably if he speaks in Australia, there's not much the Americans can do about it without the assistance of the Australians, which is why I think Anna's suggestion there may have been some involvement resonates in a certain sense. Ultimately, if he's going to be prosecuted, he's going to be prosecuted in Australia. And I think it's very difficult to imagine circumstances in which, if war crimes have been committed, a court of law could give effect to a piece of paper which purported to limit the freedom of expression of an individual to talk about the circumstance of his treatment. I'd say simply that the case that I've referred to already in the English courts reported this week deals precisely with that situation also, and I think it's going to take time for these stories to emerge. But my own view would be no gag order can ultimately be likely to succeed in an English court if the underlying issue concerns the ability of an individual to talk about his treatment, which crosses a threshold of criminality, particularly international criminality. The final question I want to come to, and it's a useful way, I think, to end, is where do we go now? I know my friends, and there's a couple of you here in the audience, think that I'm unduly optimistic on all these issues, and I am an optimistic person. I don't want to be too pessimistic, although the state of things doesn't look good. It is sort of encouraging to hear both US presidential candidates talk about this subject, even John McCain, who of course experienced firsthand being abused and being tortured in Vietnam. And if you're interested in knowing more about that, in particular, you can get, I think it's on YouTube, an extraordinary interview he gave to Dan Rather in 1997, where he described the basis on which he had come to the conclusion that torture and abuse had to be outlawed in all circumstances, and it did never produce meaningful information. He describes how he, in the end, confessed to, being part of a plot to kill children and women in Vietnam just to stop the pain from happening. Broadly, he has also gone, of course, beyond that in terms of a return to cooperative multilateralism. And I think today's news, the appointment by Senator Obama of a seasoned foreign affairs Senator, Joe Biden, indicates, I think, a return on that side of the fence to a big change of foreign policy. I listened on the news this morning to Biden's speech, and he went very far in castigating the foreign policy of the United States in terms which make it clear that if Obama is elected, there will be a very, very significant change. On the other hand, counterbalancing that, I have the terrible fear that if there were to be another attack in the United States, a lot of the gains that have occurred over the last 2-3 years, a lot of the strength that has been created by some very courageous judgments of the United States Supreme Court, which has slapped down the Bush administration in case after case after case, basically said terror is not a reason for a blank check in terms of what the executive does. A lot of those gains would be lost. So, however you look at it, it's clear that the US response to 9/11 has not worked. It has been a failure, whether you look at Iraq, whether you look at Afghanistan, whether you look at the state of the world. When you look at what's been possible in terms of the American response to Russia's incursions into Georgia, America is in the process of falling off the pedestal, and I think America will come to recognize that the system of rules that it put in place 40 years ago with the support of countries like Australia and the United Kingdom have served it remarkably well. And it will want to make sure that as new powers emerge, China, India, Russia again, they will want to make sure that those powers are caught by a rules-based system which limits their ability to act freely and without constraint.
Well, thank you very much, Philippe and Anna. It was a wonderful, wonderful talk. You're both extraordinary writers that have done us a service in your investigations and showing us the issues around human rights and where the world's going in relation to torture, I suppose. It's great to see so many people that are prepared to come out and hear subjects such as that. So thank you very much. Thank you.